into the courtroom. I'm asking the attorneys in the first case to start their videos. Ms. Can will not have access to a video. Perfect. Judge Rogers, may I open court?
Yes, please do.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 17-1276 et al. National Postal Policy Council petitioner versus Postal Regulatory Commission. Ms. Can for the mailer petitioners, Mr. Belt for the petitioner U.S. Postal Service, Ms. Gersvang for the respondent.
Good morning.
Good morning, Your Honor, and may it please the court. My name is Aisha Khan, and I am here on behalf of the mailer petitioners. This case raises three sets of issues. I'd like to start with the threshold question that it
Ms.
presents.
Khan, can you speak more directly into your phone?
Yes, is that better?
Yes, thank you.
Okay. So what I was saying was that this case raises three distinct sets of issues. And one of them is a threshold issue, which is the statutory interpretation question of whether the system to be modified or replaced under section 3622D3 is the regulatory system or both the regulatory system and the statutory requirements. The other side's case essentially boils down to this, that the alternative system, the ability to adopt an alternative system in that statutory provision conveys the broad unilateral authority to wipe out the statutory requirements. There are several reasons why that is plainly incorrect, but I would like to speak to two of them. The first is that it is inconsistent with the text of the statute, not only with the words requirements and the word shall in D1 and D2, but also with subsection D3 itself, and in particular with the language that the power to modify or replace the system applies to the system established under this section. And I'd like to point the court to
Ms.
telecommunication.
Khan,
Yes.
Ms. Khan, did the regulatory system that the commission adopt include the price cap?
Does the regulatory system include the price cap?
Yes.
The regulatory system that they adopted includes a price cap because the price cap is a statutory requirement. So
well,
the
but the
price
point is,
cap
my point in asking the question is telling us there's a difference between the system, the regulatory system and the statutory system doesn't tell us anything if they both include the price cap.
It includes the price cap only because the statute imposes the price cap as a requirement. The price cap requirement itself is not part of the system. The price cap requirement is established by the statute rather than under the statute. And so in telecommunications,
Go ahead.
In Telecommunications Research and Action Center, a very similar situation was presented. And that was a statute in which the language said the obligation imposed under the statute. That was the language there. And the question was whether that referred to the statutory requirements or to what the FCC had done. And the court, it was about the fairness doctrine and the obligation related to the obligation to give equal time to competing viewpoints on issues of public importance. And the court said that because the statute used the words imposed under this section, that meant it was referring to what the FCC had done rather than to what the statute itself had done, rather than the statutory obligation. And that's exactly what we have here.
Well,
which is
here's the problem I have. let me just explain to you. I think the most difficult issue you face is this, and maybe you can just tell me what the answer is. And you've alluded to it. So during the first 10 years, the commission's power is limited to modify. But after that period, it can modify and adopt such alternative system as necessary. And it only imposes one requirement on that alternative system, that it's necessary to achieve the system. So under your interpretation, the phrase adopt such alternative system plays no role in the statute. That's the biggest problem I have with this. That is with your argument. It just seems to me that the statute so clearly gives the commission more power in the second, after the 10-year period, than it did in the first. And that additional power is the power to modify with only one limitation, and that limitation is not the price cap. That's what bothers me about your argument. I can't get around.
I hear you, and I will admit that it gives more power, but that's a different question than whether that enhanced power extends to the ability to jettison the statutory requirements. And let me try to explain why. If you look at section D3, it has two sentences, right? The first sentence is review the system to make sure it's meeting the objectives, the system established under this section, and see if it's meeting the objectives. That's clearly not surplusage, right? That power, that the obligation to look at the system 10 years later would not otherwise have been required. Now, if you look at the second sentence, it then says you can either modify or replace. I'm using replace as the shorthand for adopt an alternative system. That too is not surplusage, because all that says is you can take a bold approach or you can take an incremental approach. And so it authorizes the commission basically to throw out the system it adopted under Section A, which was an establishment of a system in the first place that complied with the statutory requirements. So take a bold approach, take an incremental approach, but the bold approach would not have been authorized under Section A. Right, Section A was to adopt a system, but not necessarily every year to throw out the system that you adopted under A and then replace it with something else every year for 10 years, which would have been too disruptive on the postal system. And so I don't think that the fact that it has to undertake a review and then can take a bold approach that starts afresh means that D3 is somehow surplusage. I also think that interpreting D3 to allow the commission basically to throw to the curb the entire statutory boundary that Congress established in the PAEA defies common sense. Congress in 1792 has set the ceiling for postal rates. It did it in the beginning by actually setting postal rates, 6 cents, 25 cents, depending on distance, back in 1792. It does it again in the PRA in 1970 when it says we're going to impose a cost of service ceiling on increases. And then it, for 4 to 5 years, negotiates about what's the right policy choice in 2006 when it enacts the PAEA, and it says we are going to impose a CPI price cap. And that's going to impose the ceiling, and it prioritizes.
Ms. Kahn, do you think Senator Collins misread the statute?
I do, Your Honor. I think that relying on Senator Collins' statement
really... No, I didn't say I wanted to rely on it. I just asked you whether she misinterpreted the statute.
I think she misinterpreted it, and let me try to explain why. Both the House bill and the Senate bill had a price cap. Both of them had a CPI price cap very clearly. And, you know, we have alerted the court to that with our supplemental authority filing. I think it is completely, defies complete common sense to think that Congress would have adopted a statute that would have allowed a CPI price cap to be thrown out completely. I mean, the way the PRC and the USPS.
Mrs. Khan, let me just ask you, isn't that pure speculation on your part? Congress, when the House and Senate adopt different provisions, call a conference, and during the conference, there's nothing of which I'm aware that would require the conference report to maintain a price cap. And so Judge Tatel's question, it seems to me, has to be answered in light of the power under congressional rules during a conference, a House-Senate conference, to come up with a new piece of legislation. Now, there are all kinds of procedural objections that might be raised, but none are present in this case. So both the Senate and House had caps. The conference committee met, and at least according to Senator Collins, and indeed the commission's brief, came up with this compromise. Keep it for 10 years, and then, having limited the authority of the commission by setting out these standards in great detail, said if the commission finds that the current system is not working, then it has the authority to adopt a new system. So back to Judge Tatel's question, how can the court conclude that Senator Collins, speaking on the floor, has misinterpreted what the conference committee adopted?
I think there are several aspects to legislative history.
with the one that you think is this, given the deference we are, and I assume you don't disagree with what I just said about the commission and our deference to its decision here. What is your best argument, given the deference, that this court could conclude that the commission's order here is arbitrary and capricious? What's your best argument?
I think my best argument has to do with predictable and stable rates. And it is that earlier in this same docket, the commission looked at the possibility of what was then a 5.7% one-time increase. And this was was effectively at that point what I will call a rate reset. And they said that would create, I'm going to quote for you, a shock to the system.
You're focusing on one of the statutory factors, right? Predictable rates.
Yes, so this is objective 2, predictable and stable rates.
Okay, great.
Objective, yes.
Okay.
So, and the commission decided that this proposal, which the commission itself had come up with, was considering, of a 5.7% increase above CPI was, quote, well outside the industry's experience under the PAEA system of rate making, and gave mailers a limited opportunity to make adjustments. And instead, what it proposed, at that point it was in the proposal phase, it was in Order 4258, what it proposed instead was we're going to adopt a 2% increase for 5 years, because as they put it, that reflected regular and stable timing and magnitude that would allow mailers to plan. So that's what they said. They felt like it was too dramatic. And then what they did in the end was to adopt a formula, a density formula and a retirement authority formula that led to exactly the same one-time price increase. It was 5.6. When you combine the 4.5 density and the 1.1 retirement, you come up with a 5.6% increase above above CPI to go into effect all at once. And they never reconciled. And they were so unable to predict what the authority would be. They used words like, well, this is a very modest proposal. We're going to look at what it would have been in the last many years. It would have averaged 1%.
I hear what you're saying about that, but here's my problem. You're focusing on one factor here. And the commission had all of these other factors to balance. In fact, your argument, you've made exactly the argument I would expect you to make, that the commission should have balanced some of these factors differently and in your favor. And the Postal Service looked
portion caused by poor service, or even the portion that would have been ameliorated by inefficiencies. And so what they've done is they've rewarded the decline. We had a leading economist on pricing regulation, Robert Willig, explain how what that does is it simply rewards service declines, more money. And it's irrational to ignore the central issue that animated the PAEA, which was to impose a ceiling to drive down costs. And all of this highlights why that ceiling is so important, because Congress made a policy judgment that putting a ceiling on postal rates forces what was the number one policy objective, which was to engender cost efficiencies. And when you lift that ceiling, and mind you, because of this idea of balancing, it's very hard to apply the statute. I think this is why we raised a delegation argument. Once you lift that ceiling, the whole world is open to you. To this year, it was a price cap plus. Next year,
were you? I'm sorry to ask the question this way, but were you really? I guess you were serious about the non-delegation argument. I mean, how could you have a non-delegation problem when the statute has 9 different factors and a whole factors that the agency is supposed to balance? I mean, compare that to American trucking. Do you know what the statute in American trucking said that the court said had no non-delegation problem?
Yes, Your Honor.
Requisite to the public health. That's it.
To protect public health, adequate
requisite
protection.
To the public health. No non-delegation problem. Here you have a statute that, in addition to generic language like that, tells the commission to balance 9 separate factors.
Your Honor, the problem is...
Yeah, what?
The problem is, I understand the non-delegation doctrine is not especially robust. But what we don't have in Whitman trucking is a situation where the objectives point in all different directions. They are entirely in tension with one another. That wasn't true in Whitman trucking. So imagine if in Whitman trucking, not only did it say adopt standards that are necessary, requisite to public health, but it also said, and show discretion to state rules on pollutants, or also enhance industry efficiency.
You know, just to cut this short for just a minute, because I have just a couple of quick questions, but I think that's an argument you have to make to the Supreme Court. All we have is American trucking. This is a lower federal court. And I don't know of any case that you've cited. I don't know of any case myself that would support finding a non-delegation problem here. Let me just ask you, I just have 3 quick fact questions for you. That's all. Okay, and then I'm finished. Are mailers of market dominant products captive customers?
I'm sorry, are they what with customers?
Are mailers of market dominant products captive customers?
Captive customers. Sorry,
Yes.
Your Honor, I couldn't understand if you were saying capped at or captive.
Captive.
Yeah. Well,
they
for
are.
the vast majority of the products, yes.
Okay. Question number 2. You have, the mailers have some estimates of price elasticity in their comments. Were they based only on market dominant products?
Yes, the price elasticity models that our the Brattle Declaration relied on were the Postal Service's pricing elasticity numbers. And then on top of that, they ran a regression to show that the density factor increases
but
pricing.
My question was, those were only based on market dominant products, correct?
Yes, I believe I will correct my misrepresentation after if I am wrong, but that is my current understanding.
Okay, last question. You advocate that the commission should have used this roll over forward. Right?
Yeah, well.
Does that account for changes in mail volume?
I believe it does. And I want to clarify, we were not saying they should necessarily use the roll forward model.
Mm-hmm.
What we said is this is a time-tested model for cost assessment that has been used in the past, and that they should have used that as a sanity check on this, meaning run it and use it to assess whether the density authority that they did land on was a good indicator of how to capture the cost they were trying to capture.
Okay,
All right, thank you, Ms. Khan. Judge Randolph, do you have any questions you'd like to ask at this point?
No.
Thank you. All right, so why don't we hear from counsel for the U.S. Postal Service, Mr. Belt.
Good morning, Your Honors, and may it please the court. The Postal Service has filed a separate petition challenging a different aspect of the Commission's final rule. But we agree with the Commission in several important respects. We agree that the initial price cap system failed. In fact, no one disagrees. We agree with the Commission that it has the legal authority to address that failure by altering the price cap formula. And we support the alterations the Commission made. They are helpful. But those adjustments are not themselves sufficient to achieve the financial stability objective. To do that, another step was needed. Our prices subject to the price cap needed to be allowed to reset to a compensatory and cost covering level. The Commission acknowledges that that additional step would help the system achieve the financial stability objective. The Commission also acknowledges that periodic rebasing between regulatory periods is an accepted practice in price cap regulation, but it refused to take that additional step. And so because we believe that decision, that refusal was not reasonable or reasonably explained, we ask that the case be remanded for further proceedings.
So is it your position that any rate making system that doesn't cover the full cost of service is arbitrary and capricious? Is that your position?
Our position is that any rate making system that doesn't allow the Postal Service a reasonable opportunity to cover its costs is unreasonable.
And what would you rely on in the statute for that?
I would rely on the financial stability objective, and I think there's both statutory language within that objective and the Commission's interpretation, unchallenged interpretation of that language that leads me to that conclusion. So let me start with the Commission's interpretation.
Okay, but I want to hear your answer, but would you keep in mind the question I asked Ms. Khan about this, which is, I want to hear your argument about this. I do, but it seems to me to prevail, you've got to show not just that the Commission misapplied one factor, but that its balancing of all the factors together is somehow arbitrary and capricious.
We agree with that, Your Honor.
Okay, that's what I thought.
Okay. And I guess I'll take the first set of questions first about the financial stability objective alone, and then I'll shift to the balance question. As for the financial stability, our position is that, first of all, the Postal Service cannot be financially stable unless it's covering its costs. It follows that for the rate making system then to achieve that objective, putting aside the balance, but for the system to achieve that objective, it has to at least give the Postal Service a reasonable opportunity to cover its costs. Now we know this because the Commission—
And can I ask you, is your position that the reasonable opportunity must at this point encompass 100% recovery?
It must. Yes, that our position is that the system must permit the Postal Service to cover all of its costs going forward. I'm not talking about past losses. I'm talking about from this point forward, it has to give us an opportunity to do that. Now, the Commission's view, after all, the Commission's finding that the system did not satisfy the financial stability objective was based on two things. One, that we were unable, the system prevented us from covering our total costs. That's what the Commission referred to as medium-term financial stability, and that it did not give us an opportunity to retain earnings, which necessarily follows from the idea that we weren't covering our costs. So the Commission's interpretation, that's their position too, that financial stability requires the ability to cover costs. But also, when you look at the statutory language, that objective speaks of maintaining financial stability. And maintaining financial stability presupposes that financial stability existed at the time that the system went into place. And that was in fact true at the time that under the 2006 Act, that the price cap system was in place. At that time, the Postal Service was financially stable. It was covering its costs. Also, when the statutory language speaks of financial stability, including retained earnings, if retained earnings is included as part of financial stability, it necessarily follows that cost coverage is also as a necessary component of financial stability. So that's our view on the financial stability alone. Now, Judge Tatel, turning to your question about the balance, because that's, of course, the most, I think in many respects, the most important question here. We agree with the commission that in fact, the statute is very clear that the objectives must be read in conjunction with each other. And for that reason, we're not asking for unregulated, unfettered pricing authority. Certainly, unregulated, unfettered pricing authority would achieve the financial stability objective, but it would undermine other objectives. What we're saying is the commission didn't reasonably explain how satisfying financial stability by allowing us a reasonable opportunity to cover our costs would prevent the achievement of other objectives. So that's our view, that if financial stability can be satisfied without undermining other objectives, then, and meaning, but I'm sorry. Yes.
Isn't that inherent in the commission's analysis?
It's certainly their position. I mean, they point to two objectives.
Yeah.
And in their view, allowing the system to, allowing the Postal Service to cover its costs was undermined. The objective about maximizing incentives and the objective about predictability and stability and rates. And I'll take them one at a time. As for the first objective, the maximizing incentive, I think the commission's view is that leaving a gap, a going forward gap, leaving a gap between costs and revenues will encourage us to close that gap through cost cutting. And I think that view, is inconsistent both with any reasonable price cap theory that we're aware of, and it's inconsistent with the evidence and the commission's own findings. As for the theory, the commission itself recognized that price caps don't encourage efficiency by holding the regulated entities' prices chronically underwater. And as for the efficiency incentives that are provided in that objective, they're provided by the existence of a price cap. The system that the commission has implemented in its final rule retains a price cap. And those incentives are maximized. It doesn't just say have incentives, this is maximize incentives. And the commission has said that those, and that's consistent with the legislative history, that those incentives are maximized by the prospect of turning a profit. That's the incentive, the prospect of turning a profit, not just the fear of avoiding ceasing operations. Were it otherwise, that would justify always ratcheting down the available pricing authority. And as for the evidence, if the idea is that the Postal Service should close the remaining gap through cost cutting, which I think is the commission's view, the question is whether that can reasonably be done. The commission found that we cut costs and increased efficiency over the period that the original system was in effect. It didn't find that we failed over any of those 14 years to exercise efficient management or prudent management, or that we somehow didn't take advantage of cost-cutting opportunities that were there. It hasn't pointed to any cost-cutting opportunities that would close the gap in the future. And in fact, the commission recognized at several points that further cost-cutting would be difficult in light of our legal obligations and restraints. And it endorsed the only record evidence on this topic, which said that those opportunities wouldn't even come close to closing the gap. The sort of cost-cutting opportunities of that magnitude just aren't there under current law. And I'll also add, as to the objective, that objective, it really doesn't make any logical sense. We have had a cost revenue gap for 14 years. So I don't know why there's something about preserving that gap that's supposed to suddenly incentivize new cost-cutting ideas. Those incentives have been there. And also, I'll just add that even with a rate reset and even with the adjustment factors that the commission implemented that we support, we still have ample cost-cutting incentives. We'd still have more than $80 billion of prior year losses of accumulated debt, including statutory payments that need to be made, debts that need to be paid back. and we'd still be operating under a price cap. And thus we still have every incentive to act efficiently in order to break even, or better yet, to beat the expectation of the price cap and maybe turn a profit. Moving to the predictability and stability of rates objective, the commission's analysis doesn't square the sort of claim that there's a tension there with its own uncontested interpretation of that objective's meaning. The commission said that the objective requires the system to foster adjustments that are capable of being forecast regarding both the timing and the magnitude, and they don't have sudden or extreme fluctuations. A rate reset is not inconsistent with either of those prongs, or at least the commission doesn't explain why they are. I mean, it certainly can be forecast. I mean, the commission would announce both the permissible amount and the timing. It wouldn't, or at least needn't, fluctuate, whether it's a one-time rate adjustment or one that's phased in over a period of years. And the commission said that the objective, that objective is satisfied by a system with formula rates and a mechanism limiting sort of the magnitude of future price adjustments. And the revised system has those things. I mean, it has a price cap. And the commission itself proposed a rate reset back in 2018 without ever concluding that the idea of a rate reset, which again is not it is a pretty common, at least in our understanding, pretty common practice in price cap regulation, but the commission never concluded that when it proposed the rate reset that there was anything inherently inconsistent between with the predictability and stability objective.
The commission has the authority after the 10-year review to have another review for 6 months later, a year later, 2 years later. Is that correct?
They have the authority to review. The 10-year review is not the last review. It's the first mandatory review.
Something like as appropriate thereafter. So
yes.
if after a year under the new system that the commission has put into effect, it appears that the Postal Service is still not fiscally solvent, there's nothing to prevent the commission from entertaining another petition by the Postal Service to increase the rates. Isn't that right?
That's correct, but our view is that this system right now isn't. The commission has it recognized that it has a responsibility in this 10-year review to implement changes necessary to achieve the objectives, and Section 3622 as a whole says the system has to be designed to achieve these objectives. And in our view, the commission, while doing certain things that are helpful, missed a step that would actually be designed to achieve those objectives. So I don't think that they can just say, well, we didn't achieve them now, but maybe we'll achieve them 5 years from now. I mean, the commission itself recognized that it had the obligation, having found that the system failed, which again, no party disagrees with, to actually do something that fixes it. So it basically needed a plan, and there just isn't a plan here that satisfies the objectives. I see that I'm over my time and into my rebuttal time. If the court doesn't have any further questions, we ask that the case be remanded for an additional proceeding as to the rate reset. Thank you.
All right, thank you. Let us hear from counsel for the commission.
May it please the court, I'm Dana Kerson for the Postal Regulatory Commission. The commission's order was plainly within its statutory authority, and it was a reasonable and reasonably explained response to the fact that the inflation-based price cap was getting in the way of the statutory objectives. I'm happy to answer any questions that the court might have. Otherwise, I think the court understands the issues here.
Well, could you say something about their argument about system? The difference between the regulatory and statutory systems?
Certainly, Your Honor. So the text of 3622D3 requires the commission to review the system. That's the system created by the statute of which the price cap is a part after 10 years, and provides that if the commission determines that the system is not working, is not achieving its statutory objectives, It can modify or adopt an alternative system. So it can either change it or it can replace it entirely. The price cap is plainly under the language of D1 and D3, part of that system. And this, of course, was the legislative compromise. There was a House bill where the price cap could be jettisoned at any time if the commission made certain findings. There was a Senate bill that made it permanent, and the compromise was try it for 10 years.
Do you think we need to use legislative history at all in this case?
No, Your Honor. The language of 3622 D3 is clear. The commission can adopt an alternative system as necessary to meet the objectives. That's what the commission
So
did.
you draw no obstacle from the fact that there were statutory requirements, and then there was authority given to the commission to act. Because as I understand your argument, you're not disputing the commission's obligation in making whatever judgments it reaches to consider and explain the statutory objectives, the factors, etc. So why can the court simply treat the price cap requirement as something different?
So the price cap is a requirement for the system that the commission created under A1. And
But
that is the
counsel's argument for the mailers, saying, they understand that argument as you presented it, but they say the structure of the statute, what Congress actually did, is inconsistent with the commission's reading. As I understand it, and counsel hasn't framed it this way, but Congress was required to say that any alternative system may exclude a price cap. That is now a statutory requirement.
So respectfully, the statute here gives the commission the authority to adopt an alternative system. The price cap is part of the system that the commission can adopt an alternative to. We know that was the legislative compromise, but also just looking at the statute itself, if that weren't the case, then the D3, the second sentence of D3, would be superfluous in a couple of ways. It would, the language adopt an alternative system really would not be doing any work because the commission already has the authority to modify the system, to revise the system at any time under A3. So it's not clear what adopt an alternative system would do if it couldn't be a system that is different from the system that is described in the rest of 3622.
In your view, what would Congress have had to say to make it clear that in the first 10 years, the commission had this modification authority, and after that, it had authority to adopt a system different than the one it had adopted by regulation?
I'm not sure that I understand the question, Your Honor.
Well, you know as well as I do that, the Supreme Court has talked in some instances, and more than talked, it's held that where there is a fundamental impact on the economic system affecting some major activity, the Congress has to be very explicit in saying that the agency has authority basically to disregard statutory requirements and come up with a new system on its own that, after finding the current system doesn't work, may reflect something entirely different than what Congress has conceived of as necessary for a long time. You don't think that's necessary, that any delegation is broad enough to allow the commission to just ignore the statutory requirements? That's what I want to be clear about.
So D3, the second sentence of D3, gives the commission the authority to adopt an alternative system. And then if you look at 3622, what is this system that the commission can adopt an alternative to? That system included a price cap. And that's certainly the way the drafters of the bill understood this section. Section 3622 would otherwise be superfluous. 3622 D3 would otherwise be superfluous, second sentence, because A already gives the commission the authority to revise its regulations at any time. So we know this power to adopt an alternative system is something more. There are additional preconditions that the commission can only do this after determining by notice and comment that the existing system is not meeting Congress's objectives. And then Congress said what the commission needed to consider in adopting an alternative system. And it said it needed to consider the objectives.
So your argument is that the court ought to read the statute in light of all the steps Congress required before the commission, by regulation, could adopt a different system that did not include a price cap.
Yes, Your Honor, that is certainly part of it. There are additional requirements to adopting a different system.
So that's my question. Is that the critical point here? That were the court to have any doubt, that doubt should be mitigated by the fact that Congress left in place not only the factors Judge Tatel has been discussing with counsel, but these procedural hurdles.
That's right, Your Honor. Both the commission has to make the findings. They have to find that the alternative system is necessary. So there are limits on the D3 power that are not there under the A power to just revise regulations. And then also D3 says both modify and adopt an alternative system. And adopt an alternative system would not be doing any work if it was just talking about modifying the regulations. And, you know, as Senator Collins explained,
that's your conclusion, but I'm trying to figure out what is the persuasive analysis that gets you there. In other words, is the response in part that Congress didn't have to say anymore in its statute than it said here, because, and this is not the non-delegation point, but it not only limited what the commission could do by virtue of all these factors, but the procedural requirements were burdensome before the commission could move to adopt a different system.
Yes, Your Honor. And the fact that those procedural requirements are there shows that this is some kind of additional authority that is different from the authority that is present under subsection A to revise the regulations, which of course the commission can do at any time.
What I'm trying to respond to, in addition to the line of cases I alluded to, is our court has said that, you know, delegations have to be clear. And so what is the delegation here? And the mailers say, yes, there's lots of delegation, but there's nothing to say that Congress said the commission could rewrite the statutory requirements. That's all I'm trying to figure out. What's your strongest argument to overcome that principle?
I think it's the language of the second sentence of D3. If the commission determines after notice and comment that the system is not achieving the objectives in subsection B, taking into account the factors in subsection C, the commission may, by regulation.
I understand. I mean, that's been your argument. So it's just the second sentence of D3 that you rely on.
The second sentence of D3, yes, Your Honor, the second sentence of D3 does that. And if you look at it also in the context of the entire 3622, D3 is clear by itself. It's supported by 3622 as a whole, which talks about a system of which the price cap is a part and gives the commission authority to adopt an alternative system. And then, what we're looking at here, this is under Chevron deference, and the question is whether the commission's understanding of the statute is reasonable. And I think this is clear. It's certainly a reasonable interpretation.
The question initially is, has Congress clearly spoken? That's what I've been focusing on. You get to step 2, we're in a different ballpark. All right, so I think I have your argument. Anything?
Yeah.
Oh, David?
Yeah,
Excuse me, Judge
if you don't
Tatel?
mind, I just have 2 questions. I actually only had one until counsel answered your question there. I understood your brief to argue that the statute was clear, that we didn't need to get to Chevron 2. Isn't that right?
Yes, Your Honor. I'm sorry. I thought that we were positing a situation in which somebody didn't think the statute was clear.
I get you.
I do think that the statute is clear.
I'd like to just ask you one thing about the arguments that we've heard about arbitrary and capricious. So you just heard counsel for the mailers and counsel for the Postal Service make their arguments that for each of their own reasons that the commission's order is arbitrary and capricious. I know your reaction to their brief. Do you have any reaction to the arguments you heard today that you'd like to share with us?
The commission's order here, it makes sense. It is a reasonable response to this problem that nobody really disputes, that the price cap was standing in the way of the objectives. All of the things that we've talked about today are things that the commission addressed in its order. And the commission reasonably explained why it wasn't doing each of these things. So I'm happy to talk about any questions, any places where there's any question about what the commission said in its order, but the commission addressed all of these things in its order. And
so I guess, counsel, the question is, yes, it did. And now we have 2 parties arguing, well, maybe it did. But because of problems as to how it responded to some, that means that when you look at what the commission did as a whole, you cannot conclude that its decision was not arbitrary and capricious. I mean, isn't that what you heard counsel saying? They don't argue that the commission didn't go 1, 2, 3, 4, 5, say what it thought. But as I understood their argument is on fundamental points from their perspective, the commission missed the boat. And those factors, I don't want to use factors, findings are sufficient. And in some instances, they argue, require the court to conclude that even looking at everything else the commission did, what the commission's ultimate decision in its order was arbitrary and capricious. And I understood that's what Judge Tatel was trying to get the other two counsel to focus on, and you as well. And telling us that the commission addressed each doesn't really answer.
Certainly, Your Honor. So I'm happy to address any particular one.
Well, you heard
I'll
what
start
counsel
with-
argued.
So unless there are specific questions, I will start with the Postal Service's argument that the commission should have given it more. And the commission explained it was concerned about rate increases that steep, that it wanted to take a gradual approach, that it was opening another rulemaking to consider additional authority, and it was committed to reviewing the entire system in 5 years or earlier if necessary, but that it was making a lot of changes at the same time right now, and there could be shocks or unintended consequences to that. There could be effects on mailers and mail volumes, and it wanted to make sure that it was maintaining the benefits of the rate cap or achieving the benefits that a rate cap could have of encouraging low prices. Said, yes, we are not keeping the current rate cap because rate caps don't encourage efficiency by keeping the regulated entities' prices chronically underwater. The mailers talked about that the Postal Service was not, efficient enough, and that there wasn't enough to encourage efficiency. And the commission addressed that. It said, look, sometimes you need to spend money to save money. And the Postal Service has been forced to defer capital investments and use dated, worn out, and malfunctioning facilities, vehicles, and equipment. And instead of being able to invest in efficiency, the Postal Service has cut service standards, which is contrary to congressional objectives. In terms of the roll forward methodology, we addressed that at 2402 and 2403. We said, that's about attempting to predict next year's losses. And
each of these alleged deficiencies was specifically addressed by the commission and articulated in a manner that supported its judgment not to adopt the position urged.
Absolutely, Your Honor. And the commission's bottom line here makes a lot of sense because nobody really disputes that the inflation-based price cap was standing in the way of achieving the objectives. Rates were not reasonable because they were below cost, and that was due to costs that were not within the Postal Service's control and not linked to inflation. So the Postal Service couldn't retain earnings and it couldn't invest in efficiency. But the commission also had the concern about the effect on the system of changing too many things at once. And they said, we're going to do a limited additional authority under a modified rate cap that targets those specific losses that, like inflation, the one focused on by Congress, are beyond the Postal Service's control, while trying to maintain pressure to cut costs and prevent rates from going up too rapidly. And the commission recognized that there is a lot of uncertainty here, and it will review the system again in 5 years or earlier if necessary. So in this highly technical area in which the commission was balancing a lot of things and making predictive judgments, its choice of a gradual change with review really that underscores its wisdom. And it also
Finish.
Yes, Your Honor.
You may finish your sentence.
May I ask,
Yes, Judge Randolph.
before you conclude, will you tell me again what function D3 serves in light of subsection A?
Certainly. So subsection A allows the commission to make its initial regulations, which are governed by D1, by the requirements, and to revise those regulations at any time, subject to the requirements. D3 says after 10 years, study the system, and if it's not achieving the objectives, you can adopt an entire alternative system.
Okay,
So you were,
but just, I think I get it. The authority in A is totally discretionary with the commission about whether it wants to revise its regulations. But the authority under D3 is a requirement that it take a look at whether the regulations should be revised.
it's also
After 10 years.
so D3 is also a grant of additional authority. It says if the system isn't meeting the objectives, the commission may modify the system or adopt an alternative
Oh,
system.
they could have done that under A. I mean, anytime you're modifying the system, anytime you change the regulations, and you're putting in an alternative system if you change the regulations. So I don't know that that argument goes anywhere. But the important thing is that D3 required a 10-year review, whereas A doesn't.
So D3 required a 10-year review, but the second sentence of D3 is also important. And that's where it allows the commission to adopt an alternative system. And we know that alternative system.
I think I've got your argument. All right, thanks.
Okay,
All right, thank you, counsel.
thank you.
All right, counsel for the mailers, give you a couple of minutes.
Thank you, Your Honor. I wanted to point out, and perhaps it may take re-listening to this transcript, but when the PRC's lawyer was telling you what this statute said, she brings up both what the PRC and the Postal Service did in their brief, which is to rewrite the statute. They used words like rewrite the system established by this section. They used words like the statute authorized, D3 authorizes the commission to rewrite the entire section. But that's not what the statute says. And just as easily as the commission and the Postal Service were able to modify, write their briefs, and develop their argument, illustrates how easy it would have been for Congress to make this clear. And I wanted to say that I think, Judge Rogers, you're right, that a delegation needs to be clear, especially when it's something this profound, both with respect to the impact on the economy, but the impact on the Postal Service's ability to serve as the connective tissue for which it stands and which it has always been. And so
Not an argument
I think
in your brief, however, counsel.
what argument wasn't in our brief, Your Honor?
The Supreme Court line of authority about expansive impact on the economic system.
Well, I think we have in there that a delegation needs to be clear.
Yes, that's a
when
different
it
issue.
has a profound impact on the economy. And we certainly made the argument that Congress has played a substantial role in this area, and it has always had a strong policy hand in how postal rates should be established, and to conclude that it basically said you can throw that entire statutory boundary to the curb and enter into this new no man's land where the commission can basically do essentially whatever it wants, because now you have these competing objectives.
Of course, that
attempting to
sounds
balance
like
them.
we've been over, requires ignoring all the factors, et cetera.
So
That's
your
right.
position, your position, as I get it, is that the only way Congress could have clearly authorized the Postal Commission to abandon the D1A price cap is to have expressly said so. In other words, under your view, what D3 should have said is that it can revise or adopt a new system, and it's not required, it should have added, without regard to the price cap, right? That's your position.
My position is they could have done it in a horde of different ways. They could have
No,
put
but
the word
isn't that
initial.
what you're saying? That's truly what you're saying, is that they haven't expressly authorized that. They said that to say they could come up with a revised system, an alternative system, excuse me, and only impose one requirement on it is not enough. That, to be clear here, they had to actually expressly relieve the commission of the price cap obligation, right?
No, Your Honor. Our
That's not your
position
position.
is,
Well, what should they have said? Give me an example. How could Congress have done this?
I think what they said unambiguously accomplishes what I'm saying, which is it says what's established under this section can be redone. And I
Listen,
think that
you rely on
that is
Yeah.
unambiguous with,
I get you. Now, suppose we think the statute, quite contrary to the tone of the questions you may have heard, suppose we actually think, largely because of the arguments you've made, that the statute's ambiguous. What's your best argument that we shouldn't defer to the commission? Because you
that
agree,
this
the
court,
commission, you agree that the commission is owed Chevron deference, right?
Your Honor, I agree that my position is the statute's unambiguous, and I'm hearing you to
that's not my
ask
question.
unambiguous.
I asked
you,
suppose I don't agree with you about that. Suppose I think it's ambiguous. What's the best argument that that the commission's interpretation is unreasonable? That's my question.
That under Chevron 2, this court said in Pettit that the interpretation being offered needs to be consistent with the statutory purpose and the legislative history. And I submit that it is neither. It is not consistent with the statutory purpose because the purpose of this statute was to impose a ceiling, and a ceiling that would affect costs. This court said that's the central focus of the PAEA.
Well, but suppose I don't agree with you about that. Suppose I don't think the statute clearly requires the commission to regulate in its post 10-year period, subject to the price cap. Suppose I don't agree with that. Why is what the commission's interpretation unreasonable? That's my question. You can't answer my question by saying the statute's clear. This is a hypothetical.
Well, no, I'm not.
Yeah.
I'm not telling you the statute's clear in answering the question. I'm telling you that the purpose of the statute was clear. And this court said so in A&M versus PRC. It said, and I'm quoting, the central focus of the statute was tightly restricting Postal Service rate increases and increasing efficiency.
And did we
that
say
was
that?
The central bargain.
Did we say that about the post 10-year reconsideration?
No, but you said that
Okay.
about the statute, and the 10-year review is part of the statute.
Listen, don't you have a better answer to Judge Tatel's question about
Sure,
why
give
you
it to
should
me,
not
Judge.
defer? The one argument, unfortunately, you haven't made it, but is that, well, the commission thought it was clear, and that's the only thing they did was engage in statutory analysis. They didn't get to the next step of Chevron and balance the various policies involved. And so you don't defer to an agency under step 2 of Chevron unless the agency engages in that sort of policy analysis. And they never did that under the interpretive portion of the commission's report.
I think that's right, Your Honor. I also wanted to move to what I think is the second reason that I think Chevron, another reason, which would now be a third in light of what Your Honor has added, which is the legislative history. So the commission's lawyer just said to you that the House bill had an optional price cap. That's just not true. The House bill said the price cap was a permanent price cap that could only be undone if there was a notice, opportunity to be heard, and a finding that it was reasonable, equitable, and necessary. The Senate cap said—
we've addressed this already, haven't we, in my discussion with you about the power of the conference committee?
We have. I just wanted to correct what the commission's lawyer also said in their brief, which is that the House bill made the cap optional, and that's not true. The House bill had a cap, a permanent
That's
cap.
really not an issue, counsel, in all
Okay.
fairness. I mean, we can read the
Okay,
bill.
Your Honor.
right.
I just wanted to let you know, to make
Thank
that
you.
correction. And then the last thing I wanted to say, because I know I'm out of time, is the balancing question that the court has asked several questions about. And I think it really highlights why we think the price cap needs to stay in place. Because once you enter into this terrain of it's just a free-floating set of competing objectives, it defies reason that Congress would have said, we're out of the mix now. Commission at a price cap, next year price cap plus, next year price cap plus plus, next year go back to the old system. That was the PRA, which was the cost of service regime, which is precisely what the Commission's perspective seems to allow it to do. It can ignore entirely the requirements, it can ignore the limitations, it can ignore the work share discount provisions which come after D3. And it's just a brave new world of the Commission turning into the policymaker in this area, which is the role Congress has played for 230 years.
All right, thank you. Any questions? Judge Tatel, Judge Randolph?
No.
All right. Counsel for the Postal Service?
Thank you, Your Honor. Just want to point out the mailers in their argument just now, we're talking about sort of threats to the Postal Service sort of serving as the connective tissue of society. And the Commission found that the threat to that the Postal Service serving in that capacity is a system that failed to give it a reasonable opportunity to cover its costs. And the problem we have is the Commission didn't fix that problem. It partially fixed it. It did something helpful, and we support that, but it didn't fix the system. Council stated that the Commission was entitled to act incrementally. We don't disagree with that proposition in the abstract, but there still needed to be a plan. The Commission never said in its orders below, never said that it was acting incrementally as to cost coverage. The increment that was being deferred had to do with a totally different type of pricing authority that would have, in theory, enabled the Postal Service to actually turn profits, conditioned on engaging in certain behaviors. Of course, that was all premised on the idea that this rulemaking gave the Postal Service an opportunity to cover its costs. The Commission deferred that one out of concern of trying to do too many things at once, trying to shock some unintended consequences. But at no point did they say that cost coverage was the thing being deferred.
Has Congress ever subsidized the Commission within this 10-year period?
Subsidize the Postal Service?
Yeah, the Postal Service,
Yeah.
I'm sorry.
We have not received an operating subsidy during this time. The statute is always, there are certain things, free mail for the blind and overseas voting are partially subsidized in part because those are obligations that Congress sort of separately imposed on the Postal Service. And those are reimbursements. I mean, those aren't, those are reimbursements for costs actually incurred. And then there was in the last year, because of expenses incurred, particularly as to COVID, there was sort of a reimbursement of those specific expenses. As to the statutory argument, I mean, I'll leave it to obviously to the Commission, but it isn't true. I think there was a suggestion in here that the Commission never argued that if the statute's ambiguous, it's entitled to deference. That's in fact, it did make that. It said that in its final order and its earlier orders, it made a sort of Chevron step to a type of analysis. And even
I think we were referring to the brief before us.
Oh, fair enough. Well, even then, the Commission's brief on appeal says the mailers cannot prevail, even assuming that D3 is susceptible to multiple interpretations. At a minimum, the Commission's interpretation is a reasonable reading of the statute.
Right. All right. Anything further, Counsel?
No, that's it. Thank you, Your Honors.
Thank you, Counsel. Most helpful. The court will take the case under advisement.
Case number 20-5028, Niskanen Center, appellant versus Federal Energy Regulatory Commission. Ms. Gibson for the appellant, Mr. Pfaffenroth for the appellate.
Good
Good morning, Megan Gibson on behalf of Appellant Niskanen Center. May it please.
Counsel for appellant, I cannot hear you. I hear you faintly. Could you speak directly into the mic?
Yes, is that better, Your Honor?
It is better. It's not great, but it's better. Thank you.
Apologies. Here, I'll move a little closer. I'll address two main issues.
That's much better.
Okay, excellent. I'll address two main issues under FOIA Exemption 6. First, the district court's well-intentioned error in relying on speculated harms in its order for partial production. And second, the clear public interest in full disclosure of the requested landowner lists. First, the district court erred by finding there to be a substantial privacy interest at stake in speculated harms never raised by FERC in its analysis nor supported anywhere in the record, namely a threat of protesters using the list to trespass on landowners' private property.
Well, the district court, in fairness, said, for example,
Yes, Your Honor. The
trespass.
that is the only example, clear example, that's been given by the district court and by FERC. FERC offered no examples, substantive examples of any substantial, real, true risk or threat to privacy interests on the landowners on this list, including in the administrative proceeding, as well as before the district court. So the example cited by the court is the only real example that we have. And there's no evidence of such a threat, either on the record or in the articles that were cited by.
Do you know of any case that would require such evidence? What case would you cite for the proposition that the commission has to come forth with such evidence?
Sure, Your Honor. So it's baked into the Exemption 6 test. Under Exemption 6, FERC has to demonstrate that the threat to privacy is clearly unwarranted. That language is in the statute itself and in the case law. So in all of the cases that FERC cites to, all of those cases are an opposite, as in those decisions, the courts explicitly found, one, no public interest in disclosure, and two, that often was coupled with established threats to privacy interests. So, for example, the risk of commercial solicitation, or there was evidence.
Was there evidence in that case about that, or did the court just assume that such exploitation could occur? Because I don't. In our recent cases, I looked at them pretty carefully because you cite many of them in your brief. I didn't see any cases that, and maybe I missed it, which is why I asked you the question, that require the kind of evidence you're suggesting. In fact, in Horner, which has a lot of discussion in this case, in Horner, we quote assumed, and that's a quote from the case, we quote assumed that the companies wouldn't overlook an opportunity to exploit it. So I don't see any cases that require such evidence, and in fact, as I read our cases, they don't seem to require that. And also, I think what the commission said in its brief here was just an elaboration of what it said in its decision. It's very different from Chiquita, where in Chiquita, it was really brief. Here you've got, quite a few pages of discussion, especially in the denial of the appeal, explaining the problem here. So.
Your Honor, so I'm happy to walk through some of the cases that FERC cited and is relying on.
So please do.
Yeah, so
that would be helpful. Mm-hmm.
Yeah, the distinguishing factor between this case and Horner is namely that there was no public interest at issue at all in Horner. So the balancing tests clearly weighed in favor of the privacy interest at stake. There also was financial information within the list that the lobbying group was requesting in that case. There is no financial information on this list. The only thing that would be out there if these lists were fully disclosed is the fact that a pipeline sought to take these folks' land to build their project. That's it.
Did any of those cases discuss the situation with which this court is familiar, and certainly the public is familiar, that when these pipeline proposals become public, there is often negative reaction, such that there are demonstrations, there are other contacts, unwanted contacts with property owners and the like. So I'm trying to understand whether in this type of situation, where the court has acknowledged that sometimes it's obvious, what is the concern? Must the court require the agency to be express about it? And I understand your point about you can distinguish each of these cases. But what I was interested in was, it's basically what I read the district court as saying.
Yes, Your Honor.
These are not his words, my words. Everybody knows. For example, trespass.
Well, Your Honor, I agree that there is a collective understanding that there can be significant opposition, namely to oil pipelines namely near Native American land. And those are the two examples that were cited by FERC. But my office scoured the internet for hours looking for a single example of protesters trespassing on the land that is at issue here, namely land that is owned by individual property owners, not by a pipeline company, not by a corporation, not by the federal government. And we
No, counsel, the point is I own land, and now this plan has come out that this pipeline wants to put some pipes on my land. And I think, oh, goodness, what does that do to the value of my property? Much less the aesthetic pleasure I desire. I mean, I just don't understand what requirement you think the agency was required. What required the agency to make the type of specific finding that I think you're calling for?
Yes, Your Honor. So, I mean, the agency was required to at least proffer some significant threat to privacy here, any threat to privacy. And they offered no such threat.
Why don't you just refile your FOIA request?
For
make the same request, because the situation has totally changed. The pipeline is not going to be built. Only a fool would go protest on land where there's not going to be a pipeline, or do demonstrations or anything else. And so if you just file again, the basis on which it was denied, it no longer exists.
Well, Your Honor.
Well, why shouldn't, let me put it differently. Why shouldn't we take into account the fact that the pipeline's not going to be built? Isn't that really the strongest argument you have?
I would argue that that's in favor of full disclosure, because the risk of protesters or trespassers that the court cited to as an example is clearly no longer
valid.
Nor was it.
I thought your argument, I would have thought your answer to Judge Randolph was, you're not interested in any particular pipeline. You're interested in showing that in determining whether FERC's notice procedures are adequate, right? Isn't that's what you're up to here, right? I don't mean up to. Excuse me. That's your interest. That's your public interest, right?
Yes, Your Honor.
And whether the pipeline's going to operate or not, your examination of how FERC handled this tells you something about the integrity of their notice procedures, correct?
Precisely, and that would still be very relevant to the
Right.
proceedings.
So,
They do have ongoing ACP restoration and abandonment proceedings that require the pipeline to notify
right,
all the land on the pipe. So once again, if
right.
getting these notice procedures completely wrong, which we suspect that it is, then the landowners still have no knowledge or
Right.
that they need to intervene in these proceedings to assert their rights. Otherwise, they will waive all of those rights. So
Yeah.
notice.
Well, while I have the floor here, Ms. Gibson, let me ask you a different question. Suppose, for example, just suppose hypothetically that I think that requiring FERC to reveal names and addresses is a substantial privacy interest. Just assume that that's what I think. So then we go to the balancing, right? And we look at the public interest in balance it against the privacy interest in names and addresses. You agree, don't you, that when we look at that, we're looking at the difference between what FERC has offered and what you're seeking. In other words, it's the difference between initials and street names on the one hand, and the difference on the one hand, and on the other hand, full names and addresses, right?
Yeah, sure.
It's the incremental difference. Okay, so suppose, for example, that the publicly available records show that there are 6. This is a hypothetical. 6 affected properties on Mulberry Lane. Okay, and the landowner list that they've given you shows only 5. Doesn't that tell you everything you need to know? That tells you that one person didn't get it. And like the district court, I'm a little mystified as to why you need anything more here.
Sure, Your Honor. So,
Just stick with my hypothetical. Why wouldn't you know everything from the list you got about Mulberry Street?
yes, well, Your Honor, your hypothetical assumes that there are only 6 landowners that live on Mulberry Street.
Well, so suppose there's 100.
Yes, so let's say 100 live on a very common street name in Virginia, Lee Avenue or Lee Highway, Lee Jackson Highway. There's numerous streets and avenues, highways in Virginia that have the name Lee.
Did you make that argument to the district court? The only argument I saw you make in the district court about the difference between names and initials is that there might be people. Wait, I want to be sure I have this accurate. The only argument I think you made is that the property might have been sold to someone with the same initials.
Your Honor, that's one of the arguments that we made, but I am confident, I would have to double check the record, that at oral argument, I noted the fact that there are streets and avenues that can go on for quite some time, such as, I think I gave the example of Route 66, which is irrelevant here, but I think the district court could gather my meaning when I cited to that example. And, the track numbers of these properties are also incredibly important. So
then did you ask for track numbers?
Yes, Your Honor, we asked for all of the information, names, addresses, track numbers, city.
You did ask for track numbers. Okay.
Yes, Your Honor, we asked for full disclosure of the unredacted list, which includes track numbers.
I have a couple questions for you.
Wait, excuse me, just one thing.
Yeah.
Wait, I just want to I'm sorry, Ray, I just want to be sure I get this. So the track numbers comes from the fact that the unredacted list includes track numbers. So does the list you got include track numbers?
It's redacted, Your Honor. All of the track numbers, addresses, cities, towns, zip codes.
Okay, thank you. Great. Okay, thanks.
How do you reconcile the line of cases in this circuit and in fact in the Supreme Court with the idea that we should take into account why you want this information and what you're going to do with it, with the line of cases that say that the requester, neither the requester or why the requester once the documents or what they're going to do with it are totally irrelevant in a FOIA case?
Thank you, Your Honor. Well, in ACLU versus U.S. Department of Justice, a 2011 opinion from this court, and that court found that the court should take into account derivative uses in evaluating the impact of disclosure on the public interest.
There's no requirement that if you get this information, you can throw it in the trash can and there'd be no consequence for you. There's no way to require you to use the information in the manner in which you're now suggesting as the reason for wanting it.
Your Honor, the same argument could be made on the privacy interest side. To quote Justice Scalia in a concurring opinion in Ray, derivative use of the public benefits side and derivative use of the personal privacy side must surely go together. And there is no plausible reason, he said, to allow it for the one and bar it for the other.
Yeah. How do you think the pipeline got the information with the track numbers and the landowner's address and name? How did the pipeline get that?
With a tremendous amount of resources, Your Honor, and I suspect land agents and contractors.
It was public information. They got it. As a matter of fact, there's a regulation to that effect that requires them to go through the tax records,
Right.
the state tax records. So it's public information, right? Now, which way does that cut? Does that mean that the privacy interest is really not very strong or maybe non-existent, or that you don't need the information if you want to talk about need because you can go to the public records just like the pipeline did?
So 2 points, Your Honor. One, your hypothetical assumes that the pipeline is getting these lists correct, and that's exactly why we are requesting these lists, to ensure that FERC is fulfilling its constitutional and statutory duty to give each and every affected landowner along these pipeline routes notice, adequate due process notice of their rights.
So you're going to contact each and every landowner? If you got this information, how you wouldn't be, by looking at it, you would not be able to tell whether they've been properly given notice?
Your Honor, the public interest objective of obtaining these lists is to do a comparative analysis. And yes, we will utilize the public record available to do that comparative and chronological analysis to see the full extent to which, because we already know FERC is failing in sending each and every landowner notice, to see the extent to which FERC is failing in its duties. And the sample size that we have from the final environmental impact statement of 77 landowners who had their homes within 50 feet of this proposed project. And so there were construction drawings of each of their homes contained within the FEIS. 13 of those 77 homes, their physical addresses were deemed unavailable with engineering drawings of their homes. 13 out of 77, that's approximately 17%. If we say there's approximately 25.
So how did, if the address is wrong, then you assume they didn't get notice, but don't you have to contact the landowners personally to find out whether they really got notice?
No, Your Honor, if they don't have a correct address, then that's where they were sending notice. They never sent it.
No, I think the point is, if you had actual notice, suppose your neighbor received notice.
So that's not.
And he said, did you get this notice that this pipeline's coming through? And you say, no, I didn't. So he said, well, this pipeline's coming through. Look at this notice.
So
there were also town meetings, weren't there?
Town meetings?
Yeah. So you've got to contact the landowners.
Didn't you expressly told the district court that you had no interest in contacting the landowners, right?
Correct, Your Honor.
And you haven't changed your mind about that, right? You're not interested in contacting them. You're just interested in doing a comparison, correct? You want to compare. You want to compare who they sent notices to the addresses to see if they sent it to everybody, right?
Correct, Your Honor.
Okay.
Correct. And I just note for the court's own knowledge, there is an additional public interest issue in this case, in that there are ongoing proceedings and conversations occurring at FERC right now in the development of the Office of Public Participation. And that office, we're hoping, will take over notice provisions. And we would like to help FERC, frankly, establish some accountability measures, and having more data and understanding the full extent of FERC's failure will also inform that public interest.
I just have one more or less technical question to ask you, Ms. Gibson. You say that some of these initials that they've given you are not legible, right?
Correct, Your Honor.
Yeah, but isn't that something that the district court should just look at? I mean, we're not going to go through. I mean, they've got. You've got. Am I right? You got 800 pages. You don't expect us to go through those and decide.
No, Your Honor.
We just have the district. You have to take that to the district court, right?
Yes, Your Honor.
Okay, fine. Thanks.
All right, thank you. Let us hear counsel for FERC, Mr. Paffenroth.
May it please the court, Pete Pfaffenroth for the Federal Energy Regulatory Commission. The focus of the discussion really, I think, needs to be on what additional incremental value of this very privacy invasive disclosure of a ready-made mailing list, not just to the Niskanen Center, but to anyone, would really add for the public interest. The public already has sufficient information to know that FERC's agents, the pipeline, made substantial efforts to contact people. They may not have been completely perfect, but they were substantial. And whether or not any given individual got notice is not sufficient to incremental additional information to warrant overcoming their privacy interest. Privacy interests that the Supreme Court, for instance, in the Reporters Committee for the Freedom of the Press decision, said that, you know, it's one thing to have information in a government record, but when it's accumulated and readily possible to turn over information that's been in a computer, as opposed to something that you could perhaps laboriously go to a courthouse and gather, it's fundamentally different. And there are other decisions that have likewise
does the record in this case show that that the notice procedures got to virtually everybody? You say there may have been a few people that were missed, but is that what the record shows?
The only record evidence is what Niskanen has surmised from what it's
well, but
seen.
its argument is that it doesn't know whether it doesn't have enough information to determine whether a few people have been missed or a substantial number of people have been missed. That's their argument.
I understand. And the
you
public,
you can't. FERC doesn't know the answer to that either, does it?
FERC knows that pursuant to its regulation,
Right.
the pipeline provided multiple lists, 8, I believe, over the course of a couple of years, with very substantial efforts to provide notice. And you know, they also provided public meetings. They also
right. I understand all that, but their bottom line is they want to know, in the end, was it effective? And that's the public interest, right? That's how we think about the public interest. The public interest that they've articulated is the commission adequately notifying property owners? And I don't see. I mean, you heard my question to Ms. Gibson about Mulberry Street. I mean, like the district court, I'm a little mystified about how getting the full names can tell them anything significantly more than their initials. But I'm pushing back a little bit against your argument that I understood was that, you know, look, FERC did everything it could here, and if some people were missed, that's not significant. And I just don't know that we know that. Isn't that right?
Your Honor, I'm not suggesting that it's not significant that a few people were missed. I don't mean to suggest that. I mean to suggest that Niskanen already has more than enough information to know that the notice efforts were not absolutely perfect.
I got that. So,
and
yeah.
Yes.
So what about the argument Ms. Gibson just made about landowners that FERC failed to contact would be marked as unavailable on the landowner list, and none of them are. Well, so can you just explain this to me? would the unredacted lists show if a landowner was unavailable? Would it show that?
I believe these are mailing lists, and there's either an address or there isn't. I would point the court's attention to the declaration that—
Wait, no, but wait, hold on. I understood her argument saying that if you didn't know, if FERC didn't know, if it didn't have the address, it would have showed up as unavailable. Is that true? I'm asking because I truly don't understand this argument, but Ms. Gibson made a point of it in her brief and the argument about unavailable addresses. And maybe you could just explain to us what you think that means.
Your Honor, these are 800 pages of addresses, and I have not seen behind the redactions myself either. The reality is that Niskanen has said that there are several people who, or multiple people, a number of people who have not, for whom they can tell there is no address. And I don't know if that is because, you know, for instance, in their brief, they have a number of examples where the initials are basically the same for a number of people in roughly the same area. And I could speculate that there may be a single owner who owns a whole bunch of land in that area, and there's not a house on that land, and the owner may have actually had a house that is properly part of the list, but I can't tell you that that's definitively true. I have not seen the unredacted list, nor do I think it's really properly presented in this case factually, that there needs to be an analysis in this appeal of that granular level of analysis.
No, I understand that, but just you've seen the unredacted list, right?
I'm sorry, no, I've seen the redacted list. I have not seen the unredacted list. I was not involved.
You've seen the redacted list.
You're right. I have only seen what the court has seen.
Well, does the redacted list, wait, you've not seen the unredacted list?
I have not. I am an assistant U.S. attorney. I represent FERC, and they handle their own FOIA processing.
Okay. Well, do you know whether there's a category of people on the unredacted list who are, quote, unavailable?
I know that I do not know on the granular level of that. I know that the FERC regulation requires additional efforts by pipelines to make additional efforts. I also know that
is someone from FERC with you here?
They're listening over YouTube. I could try and email them live if you'd like.
Would you just email them and ask them? Just email and ask them if the unredacted list has a category of landowners that are, quote, unavailable.
Okay.
As a category of what, Judge Tatel?
Of landowners that are, I hope I'm asking the question right.
I just couldn't hear your question.
Unavailable.
What does unavailable mean?
Well, I'm not sure, but Ms. Gibson said that people who they didn't have address scores are unavailable. And I just want to know whether the unredacted list includes people who are unavailable. That's all. And while I've got you,
He's writing the email.
oh, I'm sorry. Tell me when you're ready.
I've sent the email.
Okay, thank you.
If I get an immediate response.
Thank you very much.
Of course,
of course. Little instant research here. Just one more question. You heard me ask Ms. Gibson about the illegible initials. I assume that if there are illegible, FERC would fix those back. You would clarify that, right?
Sure.
Yeah, of course.
I mean, the redaction in this process was done with, I guess, black boxes that were
Yeah.
applied manually with an Acrobat, and they're
Yeah.
It's a human being going through 800 plus pages, and
Yeah.
you can quibble with exactly where the black box starts and doesn't start.
But if they gave you a list of if they identified 50 initials that they couldn't read, you'd clarify that for me, right?
Sure.
Okay, thank you.
Sorry, Your Honor.
No, go ahead.
I did want to just add that the declaration that Niskanen offered from the landowner who said she was not properly contacted did indicate that the process didn't stop with these mailing lists, which are principally, I think, from 2015 and 2016. The landowner said that she may not have gotten, she didn't get these letters in the mail at that time, but she goes on to say, oh, and then on several occasions, a person showed up in person from the pipeline to try to talk to me about an easement. And so again, this is, I understand that Niskanen's point is that folks should get the notice early on so that they can be involved early on in the regulatory proceeding. I understand that argument. But the point is also that before somebody actually is subject to a taking, yeah, they're not going to have some kind of a legal proceeding where they literally don't know that their land is being taken. In the case of this woman who offered the declaration, she's at Joint Appendix 86 and 87, Pauline White. She specifically talks about how on a couple of occasions she got a phone call, and I believe she says also that the person showed up. I'm not reading it quickly enough to say that definitively, but that's my memory. So the point is that there are additional efforts, and as we point out at the end of our brief, the commission has been receptive to late intervention.
Well, we've been through that with FERC and its procedures, so let's not go down that route.
Sure, I don't intend to.
Let me just be clear here. The district court said, if you have initials of streets, isn't that enough? And on appeal, petitioner's argument is, or appellant's argument is that it needs a full name and address in order to determine whether the agency has fulfilled its obligation under the statute, which it has delegated to the pipeline to give notice, I'm going to say timely notice, to property owners. So what I'm trying to understand here is how you're reading FERC's obligation under FOIA. In other words, does it just turn over what it has, subject to invoking one of the exemptions? And then the burden is on the requesting party to point out what the deficiencies are, come back to FERC, and if FERC rejects their further arguments, then it comes into court. And when it comes into court, and we look at the statutory obligation of the agency to disclose, subject to these exemptions, what is our obligation? In other words, there have been cases in this court where this court has gone through boxes of documents to figure out what's going on. But for the reasons Judge Tatel alluded to earlier, normally we would send that kind of inquiry back to the district court. But what is your understanding of where the burden is here? That's what I'm trying to understand. The statute puts the burden on the agency. Then whoever doesn't get the information it wants can sue. I mean, I'm taking out a lot of the administrative steps. And then you get to court, and what happens?
A few points, Your Honor. So first of all, I've seen a lot of FOIA litigation, and frankly, I think a lot of FOIA litigation could be avoided if both parties, the government and agents and requesters, were able to interact more effectively during the administrative process, because I think a lot of questions can be resolved without needing to burden the courts.
It's a really interesting point.
And I think this court has acknowledged that. And to me, that was somewhat what the district court was suggesting.
Right. And I again, FERC believes that its original response was actually the proper way of balancing in light of Supreme Court precedent and precedent of this court that has emphasized that when we are talking about mailing lists or lists of hundreds of citizens, particularly those who have done nothing of their own volition to wind up in those government files, that agencies need to be very, very, very protective of those citizens' privacy rights. And so that's why FERC did what it did initially, which was to provide corporate landowners, but not to provide persons, because the Supreme Court's Exemption 6 jurisprudence talks about protecting persons' privacy.
So the pushback is, well, that's just great, but I've lost my property. An individual landowner. I didn't have notice. I didn't timely seek administrative review, and then I couldn't get into court either. So it's all very well for the agency to take that position. But I'm trying to understand, where are we when we get to court?
Well, in terms of whether or not somebody has the right to challenge the taking or to challenge the remuneration for the taking, the precedents that we cited at the tail end of our brief make very clear that so long as someone has the opportunity to question the amount that they're being paid, whether that's proper, that is what the Supreme Court has said is sufficient. So, but I know this case is not about takings. The case is about whether or not FERC has provided the requisite notice, acting through the pipeline applicants.
Because that's like step 2. If you're at takings,
Right. Those are policy arguments that, frankly, if Niskanen,
an individual landowner isn't going to get 100% of value. At least that's what individual landowners. So take me back, just so I understand here what's happening. Because on one ground, you can say, look, Niskanen Center already has information that there were property owners who did not receive timely notice. All right, so they lost all these administrative opportunities.
in terms of
under FERC, Congress have in mind, we want to know how agencies are functioning, and they have to reveal enough. And so if the agency keeps invoking exemptions, so we can't understand what it's doing, that's not consistent with what Congress had in mind. And so the burden is on the agency to apply these exemptions with great care. And indeed, there's a fight as to whether to be interpreted narrowly, but the point is they are exceptions to the disclosure requirement.
Your Honor, can I make a global point about FOIA litigation? Because this is something which, as somebody who's been practicing in this area for perhaps too many years, it pains me sometimes. Because in litigation, we understandably look at the parties who are before us, right? And we hear the arguments that are well advocated by those parties. Agencies are charged with protecting the public interest broadly, right? And I'm always afraid of the silent absentee parties. In this case, we're talking about literally thousands of citizens whose names could be turned over by pursuant to a request to anyone, right? And Niskanen Center disclaims wanting to do anything nefarious with these lists, but if they're turned over to Niskanen, they will be turned over to literally anyone who requests them next. And that could be somebody who realizes, I mean, it's easy to figure out where the pipeline is supposed to go. And, you know, maybe I have a business in one of the affected counties and I'm like, oh, I can plug some holes in my mailing list. Let's get the list that was given to Niskanen. There's literally, once this list goes out, there will be nothing that FERC can do to withhold the list from any other requester.
When you said that you can figure out where the pipeline would go, I wondered about that. Does the pipeline publicly disclose the route?
It does. It does, and it's part of the regulatory proceeding.
Okay.
In fact, last night, you know, in last minute preparation for this argument, I took one more look, and if you literally look on Wikipedia for Atlantic Coast Pipeline, there's a handy dandy, or maybe it wasn't Wikipedia, it was some website. It's very easy. Your first list of results for a Google image search will show you with great detail.
And you're talking about the privacy interests of the individuals. I just wondered, I asked the counsel for the petitioner here, all this information is readily available. If you have the route of the pipeline, you can get on your computer and get onto the state tax records and pull all the names and addresses up pretty easily, I think. And that's probably what the pipeline did. They didn't have people tramping around in the woods looking for evidence of who owned the property. They did it on the internet. So why is that information so I think of privacy as seclusion, and I also think of privacy of keeping personal information secret. But this information is not secret.
Your Honor, the agency is doing its best to abide by precedents of this court and the Supreme Court. And in Horner, in Reporters Committee for Freedom of the Press, in Schrecker, which talks about the incremental value of the additional information, in Judicial Watch, which talks about withholding names and addresses of people, that's a decision of this court from 2006, of people who sort of were touched in any way the development of a drug related to abortion. You know, there are many, many, many cases that
what does it tell you? Well, let me just back up. In Horner, Judge Ginsburg talked about it's not just the name and address, it's because of a particular other defining characteristic. And so what is the defining characteristic of the people who own property on an abandoned plan for a pipeline? What is the defining characteristic there?
That they're affluent enough to own land in the affected counties, that they, you know, it's not negligible that, you know, somebody who owns land as opposed to somebody who's a renter or a transient living in that area, you know, is affluent enough to own property. And that's something which, you know, would be potentially of interest to local companies that want to market in that area.
Yeah, so all they do is get on the internet and check the tax records.
But
All right, counsel, anything further that you'd like to share with the court?
I just have one more question, if that's okay.
Yes.
I was really intrigued with your point about FOIA litigation generally, and that it would be, everybody would be better served if there was more conversation between the FOIA requester and the agency. You do a lot of FOIA work, and we see a lot of FOIA cases. Why do you think that doesn't occur?
I think I'm not going to, well, the statute has, unfortunately, aspirational but largely unattainable deadlines built into it. But nonetheless, there are a number of incentives for requesters to rush to court as opposed to really having the patience, which I believe a number of these statutory amendments to the FOIA have really been aimed towards encouraging, including, you know, it's over a decade ago, they created the FOIA ombudsperson at the National Archives. Every agency has to have a FOIA ombudsperson, and Congress deliberately, I believe, created those resources in order to try and facilitate additional administrative ways to enable people to get the information they want. In this case, the record shows that Niskanen filed suit basically the moment that it believed that its administrative appeal was ripe. It was, in the agency's view, wrong because the agency had, in fact, exercised its right under the statute, although Niskanen hadn't gotten word yet because they filed it on day one when they concluded they were eligible, to extend the response deadline to the administrative appeal by 10 days. In fact, FERC did respond within those 10 days. We have not had a response in this litigation, and so therefore the court needn't reach it.
Wait,
about whether or not, sorry.
I just want to be sure I understand. So your point, and I realize we're going off a little bit, but I think your point was so interesting about FOIA cases. So in this case, they went to court, Niskanen went to court before they had any response from FERC at all?
No.
No.
They had an initial response, and then they filed an administrative appeal.
Okay.
And you're allowed 20 days to respond to
Right.
administrative appeal, but that's subject to a 10-day extension.
Right.
And they filed on either the 20th or the 21st day. I assume it was
And
the
was there
21st.
was there anything in FERC's responses that would have suggested to the plaintiffs that discussions might have been fruitful?
Frankly, I think that they'll tell you no, but I will tell you, based upon my experience seeing a lot of different FOIA cases, that there are reasons to, even where you get an unsuccessful response through the FOIA administrative process, to make additional efforts by reaching out, for instance, to the agency FOIA ombudsperson or
Right.
to the NARA. I think it's called the Office of Government Information. But frankly, I know the woman who heads that up, or at least she used to head it up. I don't know if she's still doing so. She's an amazing person and truly believes in facilitating access to government information as proper. And I think those are resources that are used far too little.
Okay, last question, I promise. And that is, and again, I'm asking you this as a lawyer who handles a lot of these cases. The district court and our court have mediation programs. Do you have any experience with, are FOIA cases, do FOIA cases ever get mediated in those programs? And if so, what's your sense of what's happening? I mean, here we have a case where the district court did the mediation in courtroom, right? But
that's true.
What's your experience been with, do you have any with whether or not our mediation programs, either court, have played a role in FOIA cases?
Yes, I do. And I'm incredibly impressed by the efforts of the mediation program. Just within the last week, I've been engaged in extensive discussions with the mediation program about a different FOIA lawsuit.
Well, let me interrupt and say the court is not supposed to know what's going on.
I'm simply, I'm not going to comment on the substance of those. I'm simply responding to Judge Tatel that, yes, I think the mediation program is interested in these kinds of lawsuits and is making genuine efforts.
But what I'm trying to focus on here is jurisprudence. Congress passes a statute. And for years, Congress passes the FOIA statute. For years, the agencies resisted, turning over materials. And then this court had a series of opinions saying, no, agencies had this obligation. And then the agency started to create FOIA offices, and we got responsive. And we've all been on cases where the agency has responded and the court has sent it back saying the agency needs to give a further response or something to that effect. But from the point of view of the requester, the statute does provide these incentives not to miss your filing deadline, either administratively or in court. So that is a problem. So that's what I understood the district court was trying to fill in a vacuum, as it were. So you have a requesting party here who is not, as I read the record, amenable to that type of negotiation. And it's looking at the statute and it's requiring that, in its view, it's entitled to this information and that the invocation of the exemption is improper. So that's the issue before this court, isn't it?
Yes, Your Honor. If the, I would quibble a little bit. Certainly there are statutory deadlines, but you have 6 years, if memory serves, to bring a FOIA lawsuit if there's no response, or if so.
Well,
I don't think there's any reason to rush to court.
Etc. In any event, there are other statutes of limitations that kick in. So I understand your point about a better way to do this. I understand why litigants come to court, and sometimes the court will send it back. It didn't happen where the court decided it would try to negotiate this itself. That didn't work. So now they're before this court. And you take the position, as I understand it, that the agency properly invoked the exemption, and that's the end of the matter, as far as this appeal is concerned.
That's right. The agency is trying, frankly, Your Honor, if the agency wasn't trying to adhere to the multiple precedents from this court and the Supreme Court that have talked about the importance of safeguarding private citizens' information that's been assembled in government records through no act of the individual citizens, it would probably be easier for the agency to stop fighting and just hand over all the information. But the agency has an obligation to the public, not just to Niskanen Center that is the plaintiff in this suit, to try and both follow the law as it understands it and to protect the public, which is ultimately Congress's fundamental purpose. And that's been recognized by multiple Exemption 6 cases going back to the 1970s when it was a brand new exemption.
So even were Niskanen not to prevail on appeal, it still has several avenues open to it, including petitioning the agency for a new rulemaking, challenging the application of the rule, et cetera. But we're getting far afield. So Judge Randolph, any questions?
No.
Thank you. Thank you, counsel.
Thank you.
All right. So counsel for appellant?
Yes, thank you, Your Honor. And just to respond briefly to some of the points made by FERC's counsel, FERC is arguing here for essentially a categorical exclusion for lists of names and addresses. And the FOIA statute in Exemption 6, namely, does not contemplate the disclosure of such lists as always and inherently being a significant threat to the privacy of individuals on this list. And I would also like to note for the court's own knowledge that other such FOIA requests have been made in other cases, and FERC has never disclosed landowner lists without a lawsuit.
Well, let's not get outside the record any more than we already have.
Yes, of course, Your Honor. The second point that I'd like to make and really hammer home is that the importance of this initial notice cannot be overstated. The Natural Gas Act provides the sole avenue of relief for landowners aggrieved by FERC orders. And under the
Counsel, I don't think that's a dispute here, with all due respect.
Well, wonderful, Your Honor.
I mean, seriously.
Yes, yeah. I
Your own property, you want to be notified in time so that you have a chance to protect your property interests.
Absolutely, Your Honor, but there was.
And so I thought the petitioner here was arguing, we want to be certain that property owners get the notice to which they are entitled. So you know already that not everybody received the notice you think they're entitled to.
Yes, but
your position is no compromise in getting full name, full address. And to the extent that other avenues are available to you to get this information, not your problem. Isn't that your position before this court?
No, Your Honor, if there was or
Well,
chronological,
you heard your responses to Judge Randolph were to the contrary. He pointed out several areas that are public now where you could get this information.
but that wouldn't tell us what was on the Atlantic Coast Pipeline, and by default, FERC.
It would not tell you what?
It would not tell us whether or not FERC sent notice to those individual landowners. It would
No, but you would know who the property owner was. You could check the list that had been filed by the pipeline with the agency to see if they were listed. If they're not, you have your information.
Your Honor, I'm afraid I don't follow your solution, because how would we, a number of these lists include PO boxes. They don't include track numbers. You know, there are PO
That's
boxes.
what you're telling me. But in response to your questions to Judge Randolph, who was saying track numbers provide you additional information, that was not your response. You just rejected that as an avenue that you and your organization was in any way obligated to pursue.
Your Honor, I don't see how we could fulfill the public interest in seeing whether or not the agency is listing a majority, at the very least, a majajority of all.
Well, we've been down this road already. All right, and your discussions with the district court
I wanted
as well.
to know,
Did I hear another judge have a question?
Yeah, I just wanted to ask Ms. Gibson about whether I understood her point about unavailable on the landowner list. Did I get that right or not?
Yes, Your Honor. So there is actually a FERC regulation, section 157.6.6D4 through 5. And when mail, for example, is returned as undeliverable when sending out these notices, the ACP was required to submit that information, noting that those people were, quote, unavailable. So those.
I'm sorry, who required it to be submitted?
FERC requires the pipeline to indicate whether or not on these lists, whether or not a landowner, their address is unavailable or mail was returned to them as undeliverable.
And your point is that the unredacted list shows no unavailables, correct?
The current.
I'm sorry, the redacted list, excuse me, shows no unavailables, correct?
Correct, Your Honor. There's
And
no.
so you're suspicious, right, that there are that there may be on the unredacted list unavailable that you don't know about, and you think that that could suggest that people aren't getting notice, correct?
Absolutely, Your Honor. Correct.
Okay. Judge Rogers, when Ms. Gibson is finished with her rebuttal, would you mind asking counsel for FERC whether you got an email response to his email?
Of course. Are we, anything further, Judge Randolph?
No.
All right. Thank you, counsel. All right. Counsel for Applee, have you received a response to your email to FERC?
I have, Your Honor.
Would
So-
you care to share it to us or
Sure.
read it
So
and then submit it as part of the record in this appeal?
if you'd like, it's very short. I can simply tell it to you.
I'm
I know,
dying of
but I
I'm
wanted
dying
it
of curiosity.
in the record for this
Yeah.
case because counsel for, appellant is entitled to see what was said.
And I have no problem if she wants to respond to what I'm about to say, because I know she's looked at the record extensively.
Okay.
So what does it say?
It says if there are blanks, and we see the blanks for some cases, Niskanen would be able to see that there's a blank because there wouldn't be a corresponding redaction. So for instance, in the case of an heir, there may be no address provided and there's a blank because we don't know who the heir is. So anyway,
Wait a minute,
that's
say
what I
that
have.
again. So, okay, just explain that. I'm sorry, but, okay, so I've now got the redacted list in front of me. Now,
So-
what's going to tell me what's?
I
and the
don't have the
redacted list-
redacted list open currently during
No,
argument,
I'm
but
not
I could
asking
try.
for a specific
But
one.
what I've been told, sorry, Your Honor, is that there are there are blanks, and Niskanen should be able to see those blanks in the list, because there's nothing to redact if there's no corresponding address.
All right, thank you. Let the court take the case under advisement.
This honorable court is now adjourned until Tuesday, September 14th at 9:30 a.m.